Good afternoon, everyone. We're going to start our next session. I'm rather pressed to start it because I understand if I do within 15 seconds, I will be the first panel to start on time, or almost. So here we go. My name is Patricia Vizera-Sellers. I'm the Special Advisor for Gender at the International Criminal Court, and I teach international criminal law at Oxford University. But prior to that, I see many friendly faces and former colleagues and current colleagues and practitioners. I was at the ICTY for 13 years. And so it is a heartfelt honor to be able to moderate this panel with extremely distinguished guests and practitioners. I feel like we are among family. And I think it is really taking a type of family to make much of the ICTY. And I think today that's why we're a little nostalgic, as if brothers and sisters and cousins might be going away, might be distancing themselves more. We want to know, well, what is the trace that will stay? We've talked about politics today, we've talked about outreach, we've talked about history. Well, now we're going to talk a little bit more about the core of the ICTY, which is law. There are three types of segments of law that have bound all of the cases together. Procedural law, the substantive law, and part of that law that relates to criminal responsibility. And the panelists here today will each present in 5 to 8 minute segments, a little bit of flexibility, yes, different aspects of procedure, substance, and criminal responsibility. They'll respond to a question, and then we'll open it up for discussion. Well, let me first proceed by saying, when we look at the procedural law of the ICTY, we've already had some reflection upon it. Judge Odio Benito spoke about Rule 96, which was the first procedural law relating to sexual violence under international, humanitarian, or criminal law. And there were certain aspects of the ICTY procedural law that I think went very much under the radar screen, but that now are part of what I would call customary law. And one is, and it comes out of Rule 96, is that the voice of the victim does not have to be corroborated, meaning that corroborative evidence, if available, is fine, but was not a prerequisite in terms of submission of evidence before a trial chamber. This leads us into Procedural Rule 89 about submission of evidence before the trial chamber. And another rule that came out via the practice is that witnesses who are traumatized are not necessarily unreliable or untruthful witnesses. This was first used in cases of sexual violence, but now it has been transformed into a general rule of witness testimony, but really of an admissibility rule. When we move on to the substantive law of the tribunal, I think we can be just as intrigued. One of the substantive crimes is torture. In particular, torture is a crime against humanity. Torture is a crime against humanity comes into the ICTY statute, having been picked up from Control Council number 10, not from Nuremberg. But once it gets to the ICTY statute, it does take on an inquisitive life of its own. Is torture as a crime against humanity the same as it is under the Torture Convention, a human rights crime? Not as it proceeds through forensia or through Kunaratz. It takes on an identity that really responds to the nature of the torture crimes and the evidence that we saw at the ICTY. And then lastly, the issue we'll be dealing with will be criminal responsibility. Now, I know that you think I'm going to run right to JCE number 3. Professor Ambos, are you in the room? No. But I do have to say that criminal responsibility, that for some people would probably be one of the most boring subjects, certainly wasn't that at the ICTY, particularly with JCE 3. But there were other very important aspects of criminal responsibility, and that included just aiding and abetting, the absence of conspiracy, the juxtaposition of 7.1, direct criminal responsibility, with Article 7.3, indirect criminal responsibility. And I think some of our presenters today will be able to go through these various issues. So let me start with this illustrious panel. Sitting to my right, needing no introduction since the days of the big fishes and the little fishes, is Judge Alphonse Ori, a treasure among us. Oh, you know what? I'm left-handed. That's why I said sitting to my right. Excuse me. Sitting to my real right, you know, is Captain Makiul, who's right now the director of the Triple MI, our aspirations and our hope for the future of international criminal law. Sitting to my further left is Professor Sleuter from the University of Amsterdam. And welcome, thank you very much. And he did tell me that he used to be an intern at the ICTY. Yes, I mentioned it, right? And then sitting to my further right, certainly needing no introduction, quite an institution at the ICTY, is Judge Pokar, previous president, current judge. Thank you very much for coming. Again, to my left, I've just met is Stephen Hill, who is the legal advisor and director of legal affairs at the North Atlantic Treaty Organization, NATO. Welcome among us. And to my furthest right, I believe is Saint Shabbos of good friend Bill Shabbos, who of course is well known for genocide, but much more within the, no, not for committing genocide, not for committing genocide, Bill, but for your studious works on genocide, but really for your studious works on atrocity crimes, including the International Criminal Court, but also for the Universal Declaration of Human Rights, an astounding scholar among us. So I thank all the panel, but we will start today with Judge Uri, please.
Thank you very much. I'm at least happy that today it was established not only once, but even twice, that there never was counsel of a small fish. But okay, one of the first questions we always put to ourselves in the morning when we were in the Tadic defense was, have the rules been changed overnight? And that's the topic what I'll talk about, because before the Tadic judgment was delivered in first instance, the rules had been changed already 10 times. And now, 24 years doesn't sound well. I mean, the 50 sounds far better. We have 50 amendments to the rules of procedure and evidence. So I would like to take you, just touch upon a few matters in the procedure which has been changed since the very beginning. First of all, some matters were not in the rules at all. For example, the safe conduct for witnesses, which was a very common feature of international cooperation in criminal matters, was not in the rules. And I remember that in the Tadic defense we argued that there should be a safe conduct in order to assure that all the witnesses could appear and would not be afraid of arrest. And I still remember Brenda Hollis saying, we shouldn't do this. What would the Dutch government say about it? I could answer that question. It is in the host agreement. So the Dutch government had no problem whatsoever. Why did we have to argue this in court? Because the defense had no standing at that point in time in the Rules Committee, even if still now they have no voting rights, but it's still there. And I would have wished to defend this in the Rules Committee. But finally, everything went fine. It never appeared in the rules. It's all done under Rule 54, but that's where we are. Of course, another matter which was not in the rules at the time, and Mark Harmon spoke about it this morning, was the plea agreement. So I'll not further elaborate on that. But have the rules been changed overnight? There was never a day when I didn't learn something in the Tribunal. So every day, I may come back to this, perhaps what I learned today. I already briefly mentioned Rule 54, which was a general rule, issuance of orders, summonses, warrants. But of course, they had not thought thoroughly about what it means to deal with states that might not be happy with your decisions. If you have a domestic system, of course, the state will execute your orders given as a court. Here, of course, we had major problems, and that was, and I think it was all triggered by the Krstic case, that Rule 54 bis, orders to states, was developed, entirely new. State security interests especially played an important role there. And of course, this touches upon the sensitivity of the relation between the tribunal and states. And that's not only true for the tribunal. We resolved this by adopting Rule 54 bis, in which proper attention was given to state concerns in this respect. But if, for example, the very complex relation with states, if you look at what they are doing at the ICC by, for example, adopting Rule 134 quarter, that is to excuse accused for appearing in court because they have extraordinary public duties to perform at home. I don't know whether the judges in the ICTY would have adopted such a rule, but the rule is there, and it's also a matter which is very sensitive in the relationship between a court and a state. Those were the matters that were not initially in the rules. Perhaps a few matters that were in the rules. Human rights issues, lawful detention. In the beginning, Rule 65b allowed for provisional release only in exceptional circumstances. That rule was changed over the years as well. And now, under Rule 65b, release may be ordered at any stage of the trial proceedings prior to and then all follows the existence of sufficiently compelling humanitarian grounds may be considered in granting such release. This is really a new element where apparently the judges felt uncomfortable with only in exceptional circumstances that you could release someone, and this rule was adopted. I think it's typically a human rights issue which was addressed here. I promised you that I would come back to that I learn everything, every day, a new thing. One of the things I learned today, for example, is that if you say, I will conclude, it means that you're halfway of what you want to say. So therefore, since I'm approximately halfway, I will conclude, but continue for the remainder. Another matter which was an important development in the rules of procedure and evidence was moving away a bit from the prevalent common law features of the procedure. I just mentioned two elements. First, Rule 101 initially said a convicted person may be sentenced, and that's what the rule still says, but Rule 88 has been stricken. The whole separation of conviction and sentence has been abolished pretty quickly after the tribunal was established. Another element in this context is the typically oral character of the proceedings. Initially we had Rule 92. Rule 92 dealt with confessions. But then later, Rule 92 bis, Rule 92 ter, quarter, quinquies, marks a development from pure oral proceedings, as if we would be before a jury, to the admission of written statements. 92 bis, statements without cross-examination. 92 ter, written statements, but with the facility to cross-examine the witness. 92 quarter, unavailable witnesses, or 92 quinquies, which deals with witnesses which are under threat. Another matter which was of great concern to me for many, many years, also related to fair trial issues, was Rule 94. Rule 94, which initially said that judicial notice can be taken of facts of common knowledge, nothing more. But since then, now the judges can take judicial notice of adjudicated facts as well. I must say it's a bit of a nightmare, this rule, for me. Perhaps something to discuss. And also of the authenticity of documents, which is of less concern to me. So, we learn every day, we change everything every day. One of the things I also learned was that Word stopped numbering footnotes at 10,000. But that's something I had to learn as well. There is a solution for that. It could also be that it's 20,000, but at least you see there's never a day without learning new things. And what was one of the last amendments to the rules, through which I want to address now, was the amendment to the rule how to amend the rules. The rules required that by a majority of 10 permanent judges, the rules could be amended. But we saw that we didn't have 10 judges anymore. So just prior to that happening, I think the plenary of judges was wise enough to change this rule and say that amendments to the rules could be adopted by the majority of the permanent judges composing the tribunal. I've always been very strict in court about timing, so I'm afraid that I have to be strict for myself as well. I think I got 8 minutes. Well, I shared with you 2 things I learned recently, and also I shared with you some of the changes, and they are all, I think, ready for discussion, changes in the rules of procedure and evidence over the 24 years, over the 50 amendments since the beginning of the tribunal. Thank you.
Thank you very much, Judge Uri. Well, I have a first question for you, and I won't ask your nightmare question on adjudicated facts, but since you've mentioned how often the rules have been changed, do you think there ever was or could be an issue in terms of principles of legality, of coming in the next day, maybe not literally, and having the rules of procedure evidence changed?
I think I have no major problem with the application of changed rules. Of course, we had rules for that. You cannot apply them on what happened in the past. I think it's Rule 6 or 8 of the Rules of Procedure and Evidence which deal with that. But of course, the legality in terms of if you are not happy with a situation, that you are more or less bound to keep everyone in detention, and only in exceptional circumstance you can release them, there may be some tension with basic human rights instruments. And that is, of course, a test on the legality of our rules. So to that extent, I think some of the amendments certainly helped a lot. So it's not mainly the legality, but fair trial issues have been often at the basis of amendments of the rules. And so less legality concerns, but fair trial, human rights issues, that certainly has been on our minds when we amended the rules.
Thank you very much. Now we'll go to Professor Slater, who will continue our discussion in terms of procedural evidence.
Thank you very much, and thank you for the organizers for this wonderful conference. My first memory of the ICTY was when I was a student, and a student visit was organized with the assistance of my international law professor at the University of Maastricht and first ICTY registrar Theo van Boven, and this was in 1994. The ICTY building was a construction site. I could not have expected then in 1994 how successful and important for the development of international criminal law the ICTY would become. I want to share some thoughts with you on the question whether or not an adversarial or inquisitorial type of procedure would have been preferable. Of course, this is all with the benefit of hindsight and many years of ICTY practice. And the question arises, of course, whether the choice for the adversarial system at the ICTY was wise and justified, and whether there should, at the moment of creation of the ICTY, not be more attention for addressing the pros and cons of the two diverging approaches, the two major diverging approaches to criminal justice. And again, with the benefit of hindsight, one can conclude that the adversarial system has served the ICTY very well. In my view, the ICTY procedures have been by and large fair and by and large efficient. But again, no one could predict this at the time of creation, nor will we ever know how the ICTY would have fared with an inquisitorial style of procedure. This is, of course, a bit of a what-if exercise, but not without importance. New tribunals will be set up and confronted with the same question: do we go civil or do we go common? There are, in my view, two compelling reasons why the inquisitorial procedure, if you allow me to take a position, would have been less suitable for the ICTY, and maybe also for other international criminal tribunals. The first is that there was a great deal in urgency of setting up the Yugoslav Tribunal, with the war in the former Yugoslavia ongoing and the Security Council actor under Chapter 7. No time could be wasted. A full inquisitorial system would require two organs, both the prosecutor and the investigating judge, to be up and running from the earliest stages. Not only is it very complex, but there would be quite some uncertainty how these two ICTY organs would then relate to one another in the investigative phase. And for example, how much funding and staffing would each require. The simplicity of the ICTY model is in that in the investigative stage, there's only one key organ of the tribunal, the prosecutor. The defense is of course also doing investigations, but does so generally at a later stage. Thus in the ICTY investigations, I believe three, defense, prosecutor, and an investigative judge, would have been a crowd, and the simple structure provided for by the Secretary General was, under the circumstances of urgency, the best choice. The second reason why an inquisitorial model would not have been a wise choice for the ICTY has to do with external publicity. There can be no doubt that in the case of the ICTY, and also with other international criminal tribunals, it is essential that the public, especially the communities affected, are able to properly follow the trials, including the presentation of evidence. In the adversarial system, the presentation of evidence at trial by the parties is an essential and integral part. But in inquisitorial systems, evidence is rarely fully presented at trial. The interrogation of witness pre-trial by an investigating judge, especially when combined with the secrecy of investigations, makes it as good as impossible for the public to properly follow the case. When the pre-trial investigations by a judge are very lengthy, which is likely to be the case with complex war crimes investigations, this would then deprive the public from any updates or insights in the progress of the case and the scope and nature of the evidence for a considerable period of time. One can, of course, try to remedy the situation at trial, and by hearing or presenting all the evidence again at trial. This was to some degree the situation at the ICCY in Cambodia. By calling, also I think in the interests of external publicity and to safeguard the rights to cross-examination, witnesses again at trial. But clearly this is not only burdensome for these individual witnesses, but also highly inefficient. It combines a lengthy pre-trial phase with a very lengthy trial. From what I said before, and from these two reasons, one should not conclude that a tighter grip of the judiciary on the investigations, thus a more inquisitorial approach, is by definition a bad idea in international criminal proceedings. This tighter grip could range from ensuring sufficient progress in the investigation to having a judge do the investigation at the exclusion of the parties. And this last model is the model applied by the ICCY. There may be disconcerting aspects in the way investigations are sometimes conducted by the parties, both in terms of missing an orientation towards objective fact-finding, but also because there have been incidents of interference with witnesses. If these problems would become significant and structural, a stronger grip of the judiciary on the investigations may be desirable, even inevitable. That said, one also would not know whether stronger judicial involvement in investigations would solve all of these issues. The investigating judge can equally be the target of criticism that the investigations are not sufficiently comprehensive or objective. Although in the history of the ICTY there have been incidents of imperfect investigations and interference with witnesses, I believe these problems have never been significant, let alone structural. I would thus conclude on this point that the creation of an investigating judge in the ICTY procedure would have been pointless and would have come at too big a price in terms of being less efficient and less transparent. Again, we can say this all with the benefit of hindsight. What then is the legacy of ICTY in terms of procedure? Does it mean that the adversarial system should prevail generally in international criminal proceedings? Of course, there's no one-size-fits-all model for procedures of international criminal tribunals. It has to be customized and fit the needs of each particular international criminal court. The internationalized courts, the hybrid model, of course, there is a decisive influence from the national system. What can be said is that the adversarial model has proven to be very successful. And the fully inquisitorial procedure's drawbacks, namely lack of transparency and a problem with a lack of external publicity, seem to be unsurmountable obstacles in the field of international criminal justice. Therefore, this is my conclusion, the adversarial system is the best choice in international criminal proceedings. Thank you.
Thank you, Professor Sluiter. But then I do have a question that I would like to ask you because I think our descendants will look back and ask this question. What about the partie civile? Should that have been included within the ICTY?
Yes, well, thank you. Yes, it is not impossible to combine victim participation with a adversarial procedure. It is more complex and would have taken far more time. If there would have been large-scale victim participation at the ICTY, it's likely the ICTY could not have finished this amount of cases. In addition, one can also, there can be certain question marks with the recent developments with victim participation and victim reparation at, for example, at the ICC. What does it mean, victim participation, when there is never a victim in the courtroom and there's one common legal representative that has to represent the views of hundreds and hundreds of victims? Is it possible that this lawyer has, on a daily basis, contact with all of his clients? And what are these instructions exactly to this lawyer from his clients? What does this mean, victim participation under these circumstances? And the same applies to victim reparations at the ICC. What is the current system of victim reparations at the ICC? It is not based on a legal claim. It is a form of collective compensation without a clear legal framework. So there's all these current problems with victim participation and victim reparation that I think the ICTY sometimes could also be fortunate it has not been confronted with these problems.
Thank you. We will now turn to the substance of the law, or the substantive law. And I'd ask Judge Pokar to please be our first speaker.
Thank you, Patricia. Thank you for giving the floor now on substantive law of the applied by the ICTY. As it is well known, the ICTY has essentially applied international customary law. This is a story that starts with the Security Council and with the legal counsel, actually, of the United Nations, who probably, or to a certain extent, indicated in the report to the Security Council accompanying the statute, the draft statute of the ICTY, that the tribunal should have applied customary law and not treaty law. Was a non-courageous assessment of the legal counsel because he thought that, in fact, treaty law would not have been applicable in the successor states of the former Yugoslavia. There would have been automatic succession, but could have been more courageous. But in fact, this lack of courage benefited the tribunal, because had one decided the tribunal would apply the treaties were created a lot of problems. In particular, we have to bear in mind that there was no treaty containing a code of the crimes to be applied on the applicable law, except for the Geneva Conventions and the additional Protocol 1 that have the system of the grave breaches. But that too is not a full list of crimes. That too is limited in the sense that the crimes, the elements of the crime are not spelled out. So applying the treaties would have left a lot of gaps in the application of the law. Luckily, the advice was to recommend the application of customary international law. And that was the basis of the success in the application of the law by the tribunal. Because the grave breach system is limited essentially to international conflicts. And the factual situation in the former Yugoslavia was that there were international conflicts, but at the same time, domestic conflicts, non-international conflicts. And one of the difficulties at the beginning was exactly to decide where and when the conflict was international, when it was non-international. One could apply certain rules for the international conflicts, but as to non-international conflicts, it was completely open space. There was the need to access customary international law, but how to do that assessment was not very easy, except by extending essentially the regime for international conflicts to non-international conflicts. And that's what, in fact, the Tadic decision did in '95. In fact, it's, I cannot of course, argue on the reasoning brought, but in fact, it said that the same rules that apply in international conflicts apply also under customary law in non-international conflicts. It was a difficult task. The Tadic decision was a courageous decision and helped all the following case law to deal with this matter. But in a way, the first decisions going to two directions. Once you have a better law, a clearer law as to international conflicts, so the idea is to adopt a wider notion possible of international conflicts. That was done with the famous question of the overall control, and taking a different position as the position taken by the ICJ on this matter, entering the confrontation with the ICJ on this point. On the other hand, that too could not resolve all the problems, and applying the clause in Article 3 of the statute that refers to laws and custom of war, it was affirmed in the Tadic decision that under the laws of custom of war, you could apply customary law. Of course, the decision here and there on the customary law was probably difficult to take. In some cases, at least. In some cases, the customary law was clear. In other cases, it required an assessment as to specific crimes, to each of the specific crimes. Now, I cannot deal with all what has been done by the Tribunal of Substantive Law, and I will try to remain in my limit. But just to take a couple of points, I think that one of the great contributions is new contribution is on the genocide. And genocide because the convention had never been applied, the 48 Convention, which is customary law at the same time. Had never been applied, and especially had never been applied in the provision in which it says that the intent must be to destroy in whole or in part. The sister institution, the ICTY, clearly applied that provision, which is limited to the in whole. And it was clear that what happened in Rwanda was done with the intent to destroy the ethnic group in whole. But the question that concerned Srebrenica, we just had a movie a moment ago, was that that was a problem whether genocide was committed in part in Srebrenica. And the tribunal had to decide in the Kirstich case when one can say that there is intent to destroy in part. Is that the numerical size of the group? Or is there must be, as compared with the whole of the ethnic group, a proportion? Or what is important is essentially the emblematic nature for the entire population of the killing of a part of it in a specific area or as a specific group. Now, this was the contribution given, and for what I can say, as you can see for the time being, is a unique contribution because it's found only in the case law of the ICTY. I already mentioned the Tadic, which is an important decision, but a second great achievement, I think, in international law made by the tribunal is the question of defining the independence of crimes against humanity as compared with war crimes. That was not very easy to be done, also because the connection with the conflict existed in Nuremberg as one of the criteria for applying the crimes against humanity, in a way could exist also in the ICTY, although the statute is more flexible on the point of the crimes against humanity, but there is still a connection with the war. So how to distinguish the one from the other? And what is extremely important is that again, we go to the first cases, especially the Tadic, made clear that the need for a connection with the armed conflict has to be regarded as abandoned in customary law, in substantive customary law, but may remain as a jurisdictional criterion. So what is in Article 5 of the statute is just to say that this tenuous connection with the conflict is a jurisdictional requirement to discuss, decide when the tribunal has jurisdiction, but does impact on the customary law. And as we know, this conclusion is endorsed now in the statute of the International Criminal Court. I don't have much time, so I think I stop here at the moment. Maybe in the discussion I can come back on something.
Thank you very much, Judge Pokar. I have a question for you also. The ICTY, as a matter of fact, has made international customary law become something that is not only vital and viable, but was an engine in order to allow us to look at evidence and to really adjudicate the evidence. Now with the International Criminal Court, now with a more treaty-based approach, what is the future of international customary law? Do we have two systems that are running simultaneously, competing, or a receding system?
I don't think there are two different systems, actually. It's true that the Rome Statute contains a codification of the law. There is no doubt of international criminal law. But is that codification exhaustive? I don't think it's the case. Customary law continues to develop. In any case, it can be crystallized in a codification, but it continues to go in parallel. Even the Convention of Genocide is not necessarily exhausting customary law. There could be other reasons that were left out, maybe when the convention was adopted, but that in the long run may, under the development of customary law. We have an example, for instance. You mentioned torture before in your introduction. Torture, we had exactly to deal with this matter. Torture is a crime codified specifically in the Convention Against Torture of 1984. And in the Furunja case, the tribunal endorsed the view that the Convention on Torture reflected customary international law. It's said explicitly in the Furunja case. And what happened later, we had a following case. Oh, bear in mind, the Convention on Torture says that torture is a crime committed by a public official. It's said explicitly. So a private person cannot commit torture under that convention, there is no doubt. But what happened in a conflict in which you have a domestic conflict, you have non-state actors. Are these non-state actors exempted from committing torture? If you apply the convention, that's the case. But in the Kunaraj case, we had that problem, and we decided under customary international law, the convention was not exhausting, codifying all customary international law, and customary international law allowed to consider the crime of torture also committed outside of by persons that were not public officials. We were helped by the Covenant on Civil and Political Rights, which have a generic expression, nobody can be submitted to torture, but does not criminalize. So it's just a provision that couldn't be applied for criminal purposes, but putting together an assessment of customary international law, we came to the conclusion that Furunja was correct because the convention reflects customary law, but does not reflect entirely customary international law. So I think that should be the case also for the future. And personally, already, I would consider that the ICC should make more application of Article 21 that allows to go to customary international law and not restrict the law as it seems to do as of now. But of course, there are, I think in the last case, in the Bembo case, there is a paragraph at least that deals with this matter, and maybe the ICC will go on considering the development of the law. So not two systems, but one system, I think.
Thank you. Custom lives then. Okay.
Yeah.
We'll turn it over to Professor Chavez now, again with substantive law.
Thank you, Patty. And I want to start by thanking President Adjus for the kind invitation to participate in this conference. I watched a film at the break about Srebrenica and was struck, well, by many things, but one of the things that stood out was towards the end, seeing Judge Rodriguez, who was the presiding judge in the Krstić trial, talking about how a policy of ethnic cleansing and a forcible transfer had evolved into full-blown genocide at Srebrenica. And it seems to me that encapsulates the case law of the tribunal when it comes to genocide. The dichotomy between the ethnic cleansing in the municipalities, which has not been characterized as genocide in the judgments, and the terrible mass murder at Srebrenica, which has. And we can see that same tension between those two, that line, shall we say, trying to trace that line between ethnic cleansing in the municipalities and full-blown genocide at Srebrenica in the recent Krstić judgment of a few weeks ago, where we have 2 counts of genocide, one for the municipalities and one for Srebrenica. And the one for the municipalities is an acquittal. The one for Srebrenica is a conviction. There is a bit of a debate going on amongst the judges in the recent Krstić decision. We have 2 judges who discussed the issue.
Mladic.
I'm sorry, Mladic.
That's okay.
Thank you. You all knew what I meant.
Yeah.
Sorry. You had 2 judges in the recent judgment who discussed the possibility of genocide and then concluded that there was not, that the numbers were not, I think that it was not a substantial enough part. You have one judge, he's sitting here on the panel, Judge Ori, who I think reflected the traditional position of the tribunal in most of the judgments, saying simply that this was a case of expulsion and that there was not the evidence to demonstrate, I'm talking again about the municipalities, the intent to exterminate or to destroy. I told Judge Ori last night I don't understand why it's called a dissenting opinion, actually, because all 3 judges voted to acquit. So the fact that one judge has one reason for acquitting and 2 others have another doesn't make the single judge dissenting judge, in my understanding of things. And I think also it's unfortunate that it's described as a dissenting judgment because it tends to suggest that it's an isolated or a marginal position, whereas in fact his position is more consistent with what the case law has been of the tribunal. Let me go back now to the founding moment. Judge Pokar has already spoken about it. The profoundly conservative approach that was taken by the lawyers in New York and by the Security Council in setting up the tribunal, an approach that defined the applicable law in terms of the subject matter jurisdiction of the court, in terms of precedents that had been set 45 years earlier. And it was as if nothing had changed. But of course, that was all dramatically transformed a few years later in the great Tadic jurisdictional decision of the 2nd of October, 1995. And what that did was gave the International Criminal Tribunal for the former Yugoslavia the largest jurisdiction that any international criminal tribunal has ever had. It's larger than the ICC's jurisdiction. It's larger than the Special Court for Sierra Leone. It's the biggest jurisdiction. Everything is there. And that judgment was really quite courageous, was the term that Judge Pokar used, and I agreed, and innovative. And of course, it was adopted then a few years later, essentially, in the Rome Statute. But it's not a judgment about genocide. I mean, it's curious that there's no real discussion at all about genocide in that decision. Now, you'll say, as one of the judges did, well, why would we discuss genocide? Tadic wasn't charged with genocide. And that, by the way, is one of the interesting features of the work of the tribunal. The International Court of Justice pointed this out in the Bosnia decision, that the prosecutor was kind of mixed in terms of the approach of charging genocide. All of the examples we've heard today. Erdemovic, who was there, who participated in the genocide, wasn't charged with genocide. Forenzia wasn't charged with genocide. The Celabici case wasn't genocide. Madame Plavsic, a senior person, wasn't charged with genocide. Well, the decision doesn't discuss it, but what it does, of course, is obviates the need to discuss genocide because it fills the huge impunity gap that's left by the by the substantive law, the law of the crimes, by the 1940s, where we either had crimes that had to be committed in the context of an international armed conflict, or we had this marvelous creation of genocide, which could be committed in time of peace but which had an exceedingly narrow definition. We had nothing for war crimes in non-international armed conflict, and nothing for atrocities that didn't involve the destruction of a national, ethnic, racial, or religious group. And all of a sudden, we have crimes against humanity in peacetime, and we have war crimes in a non-international armed conflict. Who needs genocide, finally? You've covered the ground. So I think that that's part of what happened. Now, when I say who needs genocide, of course, it's a term that is still debated and is used in important judgments, notably those of the Tribunal, but of course the Rwanda Tribunal and the International Court of Justice. But it was the pressure on it to develop legally, because for the previous decades, prior to 1995, there had been incessant calls to amend the definition of genocide. People said that it was an inert, a useless concept. It never applied, and we had to amend it. And yet, by the time we got to the Rome Conference, nobody wanted to amend it. But that wasn't because we were in a conservative mode. It was simply because there was no need to do it, because all of the expansion had gone into crimes against humanity and war crimes. I mentioned how the prosecutor didn't often charge the crime of genocide. In the first case, the first genocide case to come to trial was this intriguing case, the Jelisich case, which was decided about a year after the Rome Statute was adopted I think the judgment was in September of 1999. And Jelisich was charged with aiding and abetting genocide. He was acquitted on that charge because the judges said that they didn't have sufficient evidence that he aided and abetted anybody, because there wasn't sufficient evidence that others had perpetrated genocide. And that was the first judicial indication we had that the municipalities were not going to be characterized as a case of genocide. But then they turned to this rather strange, I think, scenario of the lone individual committing genocide. And so that case, the judgment, now stands for the principle that one person acting alone can commit the crime of genocide. Now, it's an obiter dictum, clearly. Nobody, I think, ever before a national court or an international court has ever been convicted for committing genocide alone. So it's kind of a hypothesis, it's a theoretical construct, and it's not very useful in practice. Now, that decision was then followed by several acquittals relating to genocide in the municipalities, and then, of course, the Krstić decision, followed by the other decisions about Srebrenica. And finally, and I'll conclude with just a few comments on the most recent decision in the Mladic case. The two judges who signed the opinion for the majority, not the separate opinion, I'll call it, or the concurring opinion, discuss a number of incidents. They refer to the physical perpetrators. Who are our physical perpetrators? They're the Jelisiches, and they're the Erdemoviches, and so on, the people who are actually on the ground committing the crimes, and they look at each one of the incidents and say, well, this was committed with the intent to destroy the group, part of the group, but not a substantial part of the group. To me, this is getting us off in a very unhelpful direction, into the wrong track, finally. Because really, we're not looking for what a handful of individuals, for racist crimes committed by a handful of individuals. That's where the Jelisich jurisprudence sort of leads us, but it's the wrong direction in my view. We're really looking much more, whether we call it an element of the crime or whether it's just something that is almost always necessary, which is how it's been described in the case law. We're looking for some collective, directed crime. What we see at Srebrenica, no doubt about that. But it has to be intended with the intention to destroy. Let me just say one final thought on this. When the Jelisich decision was issued in 1999, the Preparatory Commission of the International Criminal Court was in the course of drafting the elements of crimes, this secondary instrument that it has for the definitions of the crimes. And they had a rather uncontroversial draft definition of the elements of crimes for genocide that did what so many of those elements do, is just echo what the provisions say. Not particularly helpful. And one can look at the case law of the ICC to see how unimportant the elements of crimes have actually proven to be. But after the Yelisich decision came out, the Preparatory Commission decided to amend the working definition and to add a paragraph in that element of crime, in the elements of crimes for genocide, that was really an answer to Yelisich, saying, please don't do this. Please don't do this. And they have this element, which is, again, controversial because it does narrow genocide, and some people criticize it, saying this is not customary international law. Well, it may not be customary international law, but it's 160 countries agreeing on what they think the meaning of the Genocide Convention is, and they say that it should follow a manifest pattern of similar acts that is capable of achieving the result, which is the destruction in whole or in part. So I think this is, when we talk about the legacy of the ICTY, I think when it comes to genocide, the legacy is actually uncertain. There are some achievements, but it could have been neater, and the fact that the last trial judgment has this ambiguity about it doesn't change that observation, I think. To me, the interesting issue is that we have two different approaches, one at the ICC that was generated in reaction to the case law of the ICTY and the case law of the ICTY. And we'll have to see what other tribunals, be they international or national courts, are going to do with it. We won't really be able to tell the legacy of the case law in these areas, of this tribunal, of the Yugoslavia tribunal, for some years now, until some decades from now, until we see national prosecutions, and whether judges turn to the ICC law, including the elements, or to the ICTY law, because it's not the same. Thank you.
Thank you very much, Bill. And my question to you is that when the ICTY was first set up, we noticed by looking at the statute, you didn't think genocide would be one of the primary crimes, compared to the ICTR, where genocide is the first crime. So all of a sudden, the ICTY is set up. We do have a potential genocide in Srebrenica, and we have trials that have begun at the ICTR, and there is genocide everywhere you look now in terms of ad hoc tribunals. And the Yugoslav tribunal genocide seems to pale in comparison, but it's a real genocide. My question to you is that usually when, in particularly, academics talk about genocide, they get stuck on the question of intent. And one of the things that the Yugoslav tribunal did do is to not loosen the intent to commit a genocide, but to talk about accessories to genocide. And I was wondering, do you have any thoughts about being able to aid and abet a genocide, and not have the specific intent yourself, but yet be liable for the substantive crime of genocide?
Thank you. Well, we use the term specific intent, but of course the convention doesn't use the term specific intent. Specific intent has a technical meaning. I was taught a meaning for it in the law school many years ago, not very relevant really to our problem of genocide. I think that the wording of the convention, with intent to destroy, we don't use it in the definition of crimes against humanity. This idea of using the term intent has probably directed us a little bit, has probably misdirected our focus, because it has drawn our attention to the intent of individuals. And so this is the Yelisich phenomenon. It's reflected in the opinion of the two judges in the Mladic decision. And it's also meant that we've had to emphasize a distinction. This happens in Krstic. He was convicted of genocide, but then the appeals chamber changed it to a conviction for aiding and abetting. I'm a partisan of something that the pretrial chamber of the ICC, and the only real judgment on genocide adopted, this is in the arrest warrant for Bashir, is what's called the knowledge-based approach to genocide, which again is one that focuses more on on the policy element, on the fact that it's directed, that there's a plan, and it's consistent with what's in the elements of crimes. What this means is that those who participate in genocide, knowing of the plan, are perpetrators. We don't have to get into worrying about this distinction between accomplices and this notion, for example, that we have in the judgment of a few weeks ago of the physical perpetrators. I think it's more helpful, personally, and I actually think that it's more accurate and easier to convict, in the sense that, because some people are always terrified that some new theory or approach is going to provide loopholes that the guilty will escape through. But I don't believe that, because I think that if someone participates in an activity knowing what the plan is, then they're guilty of the crime. And I think that that's straightforward and actually simpler to administer than these convoluted distinctions between accomplices and main perpetrators.
Thank you very much, and that leads us into the next part of the panel, which will be discussing individual criminal responsibility. And our first presenter will be Catherine Makiul, please.
Thank you, Patricia. Let me first start by saying a word of the legacy of the Tribunal more generally before moving to my topic. As I lead the first step of this new mechanism adopted by the General Assembly last year to assist in the investigation and prosecution of the most serious crime committed in Syria, I want to stress here how much I value this legacy every day. It's both extremely important in my work, but also extremely inspiring. I'm going to speak of the Tribunal's pioneer role in identifying the doctrine of joint criminal enterprise as a form of commission under customary international law. In the cases finally adjudicated by the ICTY, JC has been retained as a mode of individual criminal responsibility in 20 cases against 35 individuals. It's been used in very different cases, as you know, in scope, of course, but also in terms of whether the person found responsible for the crime was directly involved at the crime scene or instead far remote from it, as in the leadership cases. Like many, I suppose, my first exposure to JC was when first reading the seminal Tadic appeal judgment of 1999, and I remember exactly what were the circumstances I was preparing to join UNMIC as a judge. Obviously, I never got to apply JC in Kosovo, but I had the privilege of assisting the judges in the appeal chamber dealing with the appeals in Konolinac, Vasiljevic, and Berjanin cases in particular. And challenges in these cases and in many other led the appeals chamber to revisit a number of aspects of the contours of JC without departing significantly from the main feature of this form of liability as set out in Tadic. So since everything starts from Tadic, what does it tell us? Well, you will recall that the appeals chamber had labeled as follows one of the crucial questions arising from the prosecution appeal in that case, that is whether the acts of one person can give rise to criminal culpability of another where both participate in the execution of common criminal plan. And obviously it answered this question in the positive based on its interpretation of the statute, of its objects, purpose, and also based on the very nature of many international crimes which are committed most commonly in wartime situation and involve manifestation of collective criminality in pursuance of a common criminal design or purpose. I quote the Tadic appeal chamber, which considered that to hold criminally liable as perpetrator only the person who materially performed the criminal act would disregard the role as co-perpetrators of all those who in some way made it possible for the perpetrator physically to carry out that criminal act. At the same time, depending on the circumstances, to hold the latter liable only as an aider and abettor might understate the degree of that criminal responsibility. We're just back to the question Professor Shabazz was alluding to. Well, in TEDICH, as you know, the Appeals Chamber traced the existence and evolution of the doctrine of JCE in customary international law, looking for state practice and opinio juris. It reviewed various treaties. It also reviewed the practice of prosecutors and judges at the military commissions and tribunals set up after the Second World War, and it also importantly looked into domestic practice. It looked at how those courts, prosecutors even, apply the concept of responsibility on those individuals who were not physically involved in the commission of the crime, but who, pursuing to a common design with others, were considered to have participated in the commission of these crimes. And as you know, I don't have enough time to enter into all the details of the TEDICH judgment, and I won't, but as you know, the Chamber identified three forms of joint criminal enterprise: a basic form, where all the members of the enterprise share the same intent to commit the crime; the second or systemic form of joint criminal enterprise, where participants are involved in a criminal plan that is implemented through an institutional framework, such as, but not limited to, concentration camps, and involving an organized system of ill treatment. And the third one, probably the most contested one, and I must confess, having actually adopted myself a view probably more conservative than the TEDICH Appeal Chamber did, where one or more of the participants in the JCE engage in acts that go beyond the common purpose, and but that constitute a natural or foreseeable consequence of its realization. A few more figures. JC1 was retained by the ICTY in 16 cases against 28 individuals. The second form had a much more narrow application, only 2 cases against 5 individuals, and the third one was applied in 12 cases against 22 individuals, most of whom were actually also found responsible under JC1. As I said, I will not enter into the details of the actus reus and mens rea because that would drag us too long, but just to recall that there have been challenges to whether or not JC is actually is forming part of Customary International, as you know, and some of these challenges were mounted following or based on jurisprudence of other tribunals. The Appeals Chamber, as you know, has consistently rejected those challenges and considered there was no cogent reason to depart from its jurisprudence. And the last occasion of that is to be found in the Perlich Anal case. Since TEDICH, as I said, there has been much jurisprudence actually going into defining the contours of JCE, and you find a lot of interesting developments in comparison between participation in JCE and other forms of liability. Burjanin qualified the requirement, Oidanich clarified what participation in JCE is not. It's different from membership of a criminal enterprise. It is not liability for mere membership or for conspiring to commit crimes. Vasilievich further distinguished participation in a JCE and aiding and abetting, and you can find further distinction between participation and other forms of liability under Article 7.1 in Krajisnik. One of the most significant post-TEDICH jurisprudence concerning the actus reus is actually probably Burjanin, which qualified the required contribution to a joint criminal enterprise participation. It doesn't have to be substantial, but it has to be at least a significant contribution. And if I was to only refer to one of the developments concerning mens rea, I would probably point at the Kornolenach development, explaining that or confirming that the consequence for the crimes of persecution of the requirement that participant in a basic or systemic form of JC must be shown to share the required intent, and in such cases, the prosecution must demonstrate that the accused shared the common discriminatory intent in the joint criminal enterprise. Now, what I wanted to, the most significant development I wanted to state is actually in Bergenin again, where in relation to JCE3, Bergenin decided that such form of responsibility can apply to crimes for which specific intent is required, where the commission of such crimes which do not form part of the common purpose is a reasonably foreseeable and natural consequence of the implementation of the JCE. But without wanting to be exhaustive, I want to stress another development of particular interest, and that's again in Bergenin, which actually looked at whether a JCE member can incur liability for crimes committed by perpetrators who were non-JCE members. And it answered this question in the positive, explaining how this requirement applies both in cases of JCE, of basic or extended form of JCE. Because we don't have a lot of time, I'm actually going to conclude, and I would like you to let me emphasize that at the ICTY, obviously JCE has been a very effective way to establishing the necessary linkage between individuals involved at various levels in the commission of crimes, but also, and it's not necessarily always obvious when you look only at the technical aspect of proving this form of liability, it's been very useful in establishing the connection between specific crimes, and I'm thinking here specifically of sexual violence or other gender crimes, establishing the linkage between such crimes and the broader strategic goals, such as goals of an ethnic cleansing campaign. It's obviously a very useful tool for prosecutors, but it shall remain a very demanding one, both for prosecutors and chambers. Because of its far-reaching effects, JCE requires a very strict application of applicable standards at the time of charging, in describing the very specific element of the form of the crimes and the form of liability in question, and also, obviously, for chambers at the time of adjudicating and establishing the existence of the required actus reus and mens rea components. Thank you for your attention.
Madam Akiuli, I cannot leave you without asking the question that you basically raised. Okay, we know that JCE just convict everyone on the one hand, and Judge Cassese, who wrote an article almost explaining why he believed in JCE, although he did reach a limit saying that JCE 3 he didn't feel should apply to specific intent crimes. And then there is the other part of Judge Cassese's article that says, well, joint criminal enterprise really captures how crimes unfold in the collectivity of knowing that certain crimes necessarily have more of a possibility or a probability of occurring once we unleash this intended crime. So I would like to know, where are you on the spectrum? You've mentioned I'm a little more strict, but how about if you enunciate that for us?
No, what I'm saying, I'm a little more strict. I was part of a chamber and who unanimously in the ECCC considered that in 1974, between 1974 and 1979, the state of customary international had not yet developed to a point where JCE3 was admitted. But if you accept that this was the case, that actually it was already part of customary international law at that time, I have no difficulty with the ICTY finding that JCE3 then would apply to specific intent crimes, as long as these are, there is an element of awareness and acceptance of the likelihood that a crime would occur. So that's where I stand on the spectrum.
fine. Thank you very much. Now we're going to turn to the last panelists in the presentations before we get to questions from the audience. I'd like to have Stephen Hill, who is a Senior Legal Advisor to the Secretary General of NATO, to please contribute.
Well, thank you very much, Professor Sellers, and can I first thank President Agius, as well as the organizers of these legacy dialogues, and express my very sincere appreciation for including someone with my perspective as someone who's arguably outside the circles of international criminal law, like most of you are. It's a real honor to be here to join you today, so thank you very much. NATO has, of course, consistently supported the ICTY, both politically and practically over the years. In terms of the practical support, just to recall, because I think this is part of the legacy also of the ICTY, the fact that it was able to organize these arrangements. There was support in terms of detention and transfer of accused, logistical support in the field, including such things as simply securing the perimeters of those sites and patrolling them, and then finally support in terms of evidence. So I also think, from my perspective as Secretary General Stoltenberg's legal advisor, that there are so many aspects of the ICTY's jurisprudential legacy that not only have been relevant to NATO, but will continue to be relevant to us as a political and military alliance. One very vivid example of this, before I get into the whole command responsibility issue, is the ICTY's development of the international criminal law that helps advance the fight against sexual violence in conflict. Something that, of course, Judge Odio Benito highlighted this morning, but you yourself, Professor, have been a leader in. There was my Secretary General published an op-ed earlier this month, really frankly admitting that this is an area where NATO needs to do more. And I think that the ICTY's pioneering work that shows how to strengthen global norms in the area, including, incidentally, through the application of command as superior responsibility, is actually a good example for us as we try to take up these responsibilities going forward. So let me move on to the issue of command or superior responsibility, which I think is clearly significant for us in a military alliance that's so oriented around the issue of command and control. I do believe that these form an important part of the ICTY's jurisprudential legacy, regardless of what one might think about the outcome in any specific judgment. And I should say in that regard that a disclaimer that should be familiar to many people here, but the views I'm expressing today are in my personal capacity and don't necessarily represent those of NATO or any of the allies. So it goes without saying that the concept of command and control, as I said, is at the core of NATO's work. So when we look at the jurisprudence of command or superior responsibility, it has a kind of feedback relationship with what we do, because it's driven in a way by military values and the structure of IHL, but it also can serve as a lesson to us. So I'm going to try to maybe illustrate a little bit how that is. So ensuring appropriate command and control, or what we call C2 arrangements, is really an essential requirement for our operations to go forward. But more important than that, from a legal perspective, it's really a cultural issue. So let me just read you a definition of command and control that we have in the most recent iteration of our NATO doctrine on the command and control of Allied land forces. This was just most recently revised in December 2016, and it defines command as, I quote, the authority vested in an individual of the armed forces for the direction, coordination, and control of military forces. The doctrine then goes on to explain that the concept of authority includes as essential characteristics the requirements of responsibility and accountability. The responsibilities of a commander, this is what we always advise them as legal advisors, are broad, and they include the duty to ensure that forces are trained in IHL, that operations are planned and executed in accordance with IHL, and that possible violations of IHL are investigated and addressed. And so in every single one of those elements of our daily work in advising, I think you can take something from what you've accomplished at the ICTY and operationalize it in our day-to-day work. So these are principles, of course, that's because the same spirit, I think, that is behind our notion of command and control within NATO is what animated a lot of the ICTY's reasoning. And like I say, a lot of this will help us fulfill our own responsibilities. One interesting aspect, maybe before I go into the kind of the ICTY case history, is just it's worth noting how the concepts of command and control function within multinational operations. And this has come up in the context, of course, of the ICTY's work, and I think it's useful to recall here. So in multinational operations, in NATO context, national commanders retain the legal authority over their personnel, including the disciplinary authority. So the NATO commander normally works through and with national authorities in fulfilling their responsibilities for military personnel with respect to the issues that we're talking about here. Why do I say that? It's because it becomes imperative for us to promote what we call legal interoperability and to promote internationally shared notions of the various concepts that run through command and control responsibilities. And where can we look? It's hard for us to look to necessarily any given multilateral treaty because of the difference in states parties within our alliance. You know, the Rome Statute, we have not all of our allies that are party to the Rome Statute. Same to go for the AP, the additional protocols to the Geneva Conventions. So like the ICTY in a way, we actually look towards a notion of customary IHL. And I think that in that sense, the ICTY is really something of a gold mine for us in terms of promoting multinational interoperability. So let me just go into the ICTY, what I see as the ICTY's contribution to the law of command or superior responsibility. The ICTY was instrumental in building on the post-World War II legacy by elucidating a number of aspects of how this command or superior responsibility can function in practice. In this work, as we've discussed, the ICTY laudably grounded itself in customary international law and in its statute, which refers to command or superior responsibility at Article 7.3. I'm not going to read it out, but those of you if you want to consult the text can do so. So given the very small amount of time, which I've probably already exhausted, Professor, let me just focus on one key judgment in the Celebici case in order to sketch out the basic contours of the concept of command responsibility that's been set forth by the ICTY. This is not intended as any sort of injustice to the corpus of subsequent decisions, which are clearly quite a number of them and clearly quite relevant, nor to the considerable academic debate that has developed around certain aspects of the scope of command responsibility. So, of course, the Celebici judgment was historic in that it was the first extensively reasoned decision on command responsibility, which I should say the trial chamber styles as command responsibility for failure to act by an international tribunal since Nuremberg and Tokyo. And its basic approach was followed in a large number of cases. And of course, the basic approach is the classic three essential elements that you see repeated in many doctrinal books, including, should I say, military manuals. They've almost become canonical. Those are, one, the existence of a superior-subordinate relationship, superior-subordinate relationship. Two, that the superior knew or had reason to know that the criminal act was about to be or had been committed. And three, the superior failed to take the necessary and reasonable measures to prevent the criminal act or to punish the perpetrator thereof. So I thought that in the limited time, I would just go through those elements and raise maybe a couple of comments with a view towards promoting a discussion. I'm not, especially being amongst such a venerable group of ICL experts, I don't purport to be able to give a view on these issues, but there are certainly things that come to mind when I have a look. So with regard to the first element, that is the superior-subordinate relationship, the tribunal clarified first, the requirement of effective control by the superior over the subordinate, and then second, that such effective control can have a de facto as well as a de jure character. So of course, it's this effective control that is the essential objective requirement, and I believe that the ICTY did future courts and tribunals significant service in highlighting this essential objective element. Let me say something about the insight that effective control can be of not only of a de jure, but also of a de facto nature. I would say from a kind of strategic standpoint, including a strategic standpoint of the armed forces, this is a really powerful insight in today's world. The prosecutor had, I thought, an interesting remark at the Legacy Conference in Sarajevo when he noted that in a number of contemporary conflicts, irregular armed groups cooperate to various degrees of unity with more established regular forces, both state and non-state in nature. So this happens not only in the conflicts that are the subject of the ICTY's jurisdiction, but also in many conflicts today. And I should note that the ICTY extended the notion of applicability of command or superior responsibility to not just international armed conflicts, but also internal armed conflicts in Haji Hasanovich. And so often, of course, this whole structure is done precisely for the purpose of attempting to evade responsibility or obscure liability. This technique of playing around with the contours of liability, creating confusion, et cetera, is a phenomenon that we're encountering in the NATO context. We call it hybrid warfare. But what I find very interesting for NATO is that the ICTY provided us with some intellectual tools or frameworks that we can use to understand these types of phenomenons that are key in modern conflict. You could say the same about other aspects of the ICTY's jurisprudence about the concept of command or superior responsibility. For example, the tribunal clarified that a superior can be either military or civilian. And as Professor Stan said in the morning, this is one of the areas that's been widely, I think, welcomed by the international community, perhaps unlike some of the aspects of JCE that Catherine had been discussing. So how has this notion been implemented going forward in other tribunals, like in the ICC? Well, unlike the tribunal, Article 28 of the Rome Statute seems to provide, at least for different standards for military leaders and civilian leaders. And in the Bemba case, the ICC has set forth seemingly more elaborate elements with respect to military command responsibility than those that were used in the ICTY. So there may be some sort of divergence there. I leave it more to the experts to assess. But what I do think is interesting is that the pretrial chamber in Bemba did recognize that the ICTY approach or criteria could have a certain guiding influence on the ICC. So that's one element you can see, I think, of the continuing legacy. Now, on mens rea, the tribunal has held that the superior would have to have either actual knowledge or, just to quote, possession of information of a nature which at the least would put him on notice of the risk of such offenses by indicating the need for additional investigation. So here, the ICTY was interpreting the knew or had reason to know standard that is set forth in its own statute, and that sets a fairly high bar. That said, this standard is echoed and is well received in a number of documents, such as the ICTY customary IHL study and in numerous military manuals. Again, the Rome Statute uses what is a different formulation for military commanders, namely knew or owing to the circumstances at the time should have known. And so one issue I'd like to see as things develop, but keenly interested to see to what extent this type of guiding influence that the pretrial chamber of the ICC at least cited in Bemba might be applied to looking at the mens rea standard for command responsibility going forward. So maybe just to say something about this, the mens rea standard established by the tribunal, because there's one element of it that really does resonate in a military context like NATO, and that's the need for additional investigation when certain kinds of information come to light. This, like the notion and the implications of command and control, this issue of investigations is something to which we're paying intense attention at NATO, including how to develop appropriate standards to conduct investigations. And so having this key reference as part of our core notion of command responsibility, namely the need for investigation when certain facts come to light, really helps, I think, reinforce this overall push to investigations that is part of us building and maintaining our culture of accountability. And so for that, I thank the ICTY. So just in conclusion, through its fleshing out of the doctrine of command or superior responsibility, the ICTY really has contributed to promoting and supporting a culture of accountability in militaries, not only within NATO and NATO partners, but I think around the world, including by helping develop this interoperability that is so crucial to us. And as I've tried to explain, at least from my perspective on the outside, even if there's a debate around the contours of the doctrine, and even if subsequent courts may use slightly different approaches, and I guess that remains to be seen how different the approaches are, the broad lines of the ICTY's approach are a good reflection of long-standing values associated with responsible command, and they're an important support and reinforcement to those values as we continue to evolve them as we move towards the future. So I thank you very much, Professor.
And I would like to recall that at the beginning of the ICTY, that we were indebted to several military attorneys. As a matter of fact, it was the military attorneys who basically practiced humanitarian law at that time period. But Brenda Hollis, Michael Keegan, Stefan Burgoyne, who became the first president of the Defense Bar, as well as Andrew Cayley, were former JAG or military attorneys, and Bill Fenwick, who became the head of the legal advisory section. Absolutely Canadian, yes. So what I would like to ask you right now is that we don't tend to see any type of rotation or military attorneys joining ad hoc tribunals or permanent courts. And given the fact that command responsibility as a liability theory not only applies to humanitarian law, but now is applied to crimes against humanity, could be applied to genocide, what types of manners are you undertaking to make sure that military attorneys are conscious that liability and therefore responsibility extends beyond humanitarian law of Geneva or Hague law?
Well, I think it goes in part, first of all, thank you for recognizing, I think, the contribution of a lot of JAGs. I mean, the NATO system is certainly strengthened by people who have spent formative years supporting the ICTY or working in the ICTY. And, you know, as I said in my introduction, there's a kind of a feedback factor, because it's true that a lot of the ICTY kind of values are springing out of military doctrines and of military values, but they then come back and reinforce. And so what are we doing to constantly ensure that the demands of command responsibility are kind of inculcated into our commanders, but also the legal advisors? First of all, training. And so the need to continually improve our training, not only in IHL, of course, but in international law more broadly, in human rights law, is extremely important. And as a practical matter, I was just kind of looking back at our various doctrines and manuals and our training materials that we use. Actually, so much of the ICTY's jurisprudence kind of becomes then the source material for our training. So that's one way that we do it. But I think having to deal with 29 different allies that have, like I say, different legal frameworks applicable to them, the one thing they do have applicable to them is a certain customary law basis. And so the fact that the ICTY has been able to articulate an inclusive and broad notion of customary international law is extremely important to us and to help us advance the values that you're talking about.
Thank you very much. Well, now we'll open this up to the public. I think we have at least 15 minutes in order to take some questions. I see a question here in the back and then further.
Ian Edwards, Defence Counsel at the Mechanism. This is essentially a question for Professor Slaughter, but I'd be interested in hearing the views of the other panelists. To the extent that the procedural law at the ICTY has essentially reflected the common law system, are there any features of the civil law system that could have benefited the ICTY's procedural law? In other words, could there have been a successful marriage of the adversarial and inquisitorial systems? And if they could, how?
There's a question over here.
Thanks very much. Jen Syverson, Leiden University. Thanks for a really fantastic and well-moderated panel. My question's regarding the sort of micro-level practice direction at different chambers and different trials at the ICTY, and the sort of tension between fragmentation and innovation. I recognize that it's helpful for judges to be able to guide their trial and control their courtroom, but there was a remarkable diversity of daily procedure in terms of how evidence is tendered, how it's admitted, how examination is conducted within different chambers and trials. And I'm wondering if there's any advice, particularly Judges Ori and Bukhar, but generally, if they think that was helpful at the ICTY to have a lot of flexibility in different trials, or whether they think the ICC should try for a more homogeneous, unified approach in terms of the micro level of how trials are brought forward. Thanks very much.
Thank you. We'll take one more question. Oh, well, sir, I'm going to, and then we'll come back to you. Yes.
Hi, thank you very much for your amazing contributions today. My name is Amir Cengic. I'm formerly legal officer with ICTY Chambers. I also worked in the ICTY Defense and Registry. My question is to Professor Shabas. You mentioned that, in your view, the legacy of the ICTY with regard to genocide is uncertain, and you cited or you referred to the new requirement at the ICC with regard to the overall pattern or the manifest pattern. I'm wondering, should a case similar to Srebrenica arise in the future, would the ICC in a similar situation rule that such acts constitute genocide? In particular, does the overall pattern, this manifest pattern, can it be applied at a municipal level, or in your view, should it be something wider at a state level? Thank you very much.
Okay, I think we'll start responding to the questions. Can I turn to Professor Schleuter for the first one concerning, does the inquisitorial system have something to offer?
Oh, yes. Well, thank you. Coming from the Netherlands, I think there has been quite some literature on the combination between the two systems, especially Damaska has written on this, that one has to be careful in combining two different justice systems because each is a delicate balance. That said, the first annual report, Cassese wrote that there was a choice was being made for the adversarial system, but with three important inquisitorial elements, namely no technical rules of evidence, the judges can be actively engaged in fact-finding, and there shall be no plea bargaining. On each of these 3 points, one can debate a long time to what degree they have been really applied in ICTY practice. For example, plea bargaining came in the game quite fast and was widely applied to a certain extent. So, this combination is possible, but I think also the words of Cassese were more meant to give the civil law countries something recognizable or some sort of reassurance that they were not totally forgotten, then it was really, there was really a lot of thought put into an effective combination of these elements in the adversarial system.
Does anyone else want to respond to that? If not, then I'll move to the question concerning, if I understood correctly, the proliferation of practice directives, possibly micromanaging of the courtroom itself by the judges. And of course, I turn to Judge Pokar and Judge Woree to respond to that.
I didn't get exactly what the question is in substance. Can you clarify it?
Could I also ask, what do you mean exactly by micromanagement in the courtroom? I mean, if you don't micromanage the courtroom, it will be chaos very soon. So if you could please further explain what you had on your mind.
I'm sure it was my lack of clarity. I wasn't meaning micromanagement. I just meant differences in approach in terms in different trials, how you would tender evidence, whether it would be accepted or not. Different trials, different judges took different approaches in each chamber. I think this is continued at the ICC, and I wonder if you feel if that's an accurate characterization and if it's a problem.
If I could say something about it.
You can say anything.
Yes, it's all. I think, well, the different approaches. I mean, if you want to avoid that, choose judges in the future, all having the same background, the same experience, coming from the same system. What you see is what happens is that when I'm working with an Egyptian and a Colombian judge, we try to find a way of common understanding on how we would deal with that case. And the same is true if I work with a German and a South African judge. You have to, I mean, to develop a unique system, and this is the approach, might not work. And I do understand for defense counsel it must be horrible to adapt to all these approaches, but to standardize that is, I wouldn't expect that it's easy to be done. But this is not specific for international criminal tribunals. I've been working as defense counsel for 17 years. And I've practiced in several countries. I never saw one chamber composed A, B, and C to do it in the same way as the others did it. It's also a matter of personality of the judges. What I do know is that in the beginning, many of the common law, if I could say so, judges said, well, we'd never do what you civil law judges do to interfere and to intervene so much when the parties are presenting their case. And I also know that the approach by the civil law judges will never let the parties go the way in which they want to go. Finally, what you see, it's all levels a bit, and it comes to a kind of a new balance. But that balance is not established exactly in the same way in all courtrooms. And I can tell you, when I was defending in Tadic, I had some troubles now and then with the approach of the trial chamber then, and also with the appeals chamber. I'm afraid it's your fate.
Yes, Judge Pokar, yes.
Just one word as concerns the appeals. The appeals is mainly on the law, of course. It's on facts also in certain cases, but it's mainly on the law applicable. But there too, you have a problem of different views, different interpretations, which is common also to a certain extent in domestic jurisdictions. The domestic jurisdictions have normally a Supreme Court that helps to unify the law. We didn't have a Supreme Court to unify the law. The appeal chamber had to do the two functions of appeal and Supreme Court, but it's in a way unavoidable that you have different views, different opinions. I understand that at the beginning it might have been more a nightmare, but also for the prosecution, applying the law and not knowing what the law would be, how customary law would be assessed by a court. And if you look, we can't go into that now, but if you look at the initial indictments, some are very prudent. Very prudent. Take, for instance, we started this morning with the sex crimes. Look at the first indictment of the prosecution. Some are prudent. You know better than me, but some are very prudent and insist on torture, for instance, because torture was a clear crime established under the law. But going on rape, sex assault was more difficult because there was no clear uncertainty how the tribunal would assess these crimes. And of course, the prosecutors didn't want to lose the cases. Yeah.
Thank you very much. We'll proceed to the third question. I think now their question, will there be a life of genocide of a substantive crime? Is it uncertain?
I'm just tempted to intervene on the last question because I love these stories about civil law and common law interacting. And I'm reminded of at the Rwanda Tribunal back in '97, I attended some of the hearings in the Akayesu case. And I was there when the first victim of rape testified and was being kind of rather brutally questioned by the defense lawyer. And at the break, I spoke to the prosecutor, Pierre Prosper, and I said, Pierre, why aren't you objecting? Why aren't you fighting this? And he looked at me, he said, Judge Kama doesn't like objections. So this is, how that system works. The question about genocide in Srebrenica, thank you for the question. As I understood it, it's saying if we had similar facts to the fact situation in Srebrenica, but we transplanted the venue to the forum, to the ICC, with this additional element, would the decision be different? I don't think it would be. I don't really think that that's the issue. Srebrenica it's not a Yelosich case. It's not one madman who's out killing people, but it's clearly a planned, organized massacre where many of the participants are well aware of what's going on. So I don't think that would be the issue at all, and I don't think that would cause any problem. The real difficulty with the Srebrenica precedent, because it stands alone in a way of all the horrors of the war, a very, very terrible, special event in the conflict, and as Judge Pokar explained, really that's where the innovation is of the substantial of the in whole or in part. It's the issue in whole or in part, and that's where that development, where that's that contribution, because it's as genocides go, this is a relatively small group compared to previous judicial pronouncements. Eichmann, where we're talking about millions, Rwanda, where we're talking about hundreds of thousands, and now we have 7,000 to 8,000. So that's the part. And if you had facts similar to that, or very similar to that, I assume a tribunal would say, well, we have a precedent. We're going to follow it. The problem is, what if you change the proportions? And that's the difficulty. And I don't think that we don't have any great guidance from the case law of the tribunal as to what happens then. If for example, it's 400 or 500 people, the case law doesn't answer that problem. It's a general principle that could be applied in different ways, and I think it's hard to predict what a tribunal would do with it.
Thank you very much. Well, I'm going to have to at least reflect the discipline of the panelists and have this panel start within 3 minutes of its official cutoff time, Carsten, okay? So I would really like to ask you to join me in thanking the intervention of each of the panelists. It's been a very wonderful conversation.